Hi everyone, today we will see one of the short topics called gains of learning, which have been frequently asked in exams. So we all know that we have been provided with education, and with the help of that education we learn a lot, and we used to get job, we earn some money and accumulate some wealth. So these are the gains of learning. So what would happen if the education is provided with the help of the ancestral property? Suppose you have an ancestral property of your father, and if your father provides education to you with the help of that ancestral property, subsequently you get some job or you set up some business, with the help of that earn some money, and after that you purchase some property. So now the question arises is, whatever property acquired by you is a self-acquired property or coparcenary property? This question arises because the education was given to you with the help of ancestral property. That is, by detrimenting the ancestral property, you got some education, and with the help of education, you acquire this property. So this question is answered with the help of some of the case laws. Suppose a person receives ordinary education at the expense of an ancestral property, and subsequent acquisition by him has to be considered as self-acquired property. This is decided in Mehta versus Rewa case. Instead, if he receives a specialized training by utilizing the ancestral property, and subsequent acquisition by him has to be considered as coparcenary property. That is decided in Gokulshin versus Hukumchan case. So this is how the Privy Council drew a distinction of how to decide whether the property belongs to self-acquired or coparcenary property. So if a person receives ordinary education by utilizing the ancestral property, and subsequent acquisition by him will be considered as self-acquired. Instead, if he receives specialized training by utilizing the ancestral property, that has to be considered as coparcenary property. We will see this case law, Gokulshin versus Kukumchan case, in detail to understand this specialized training concept. So what happens in Gokulshin versus Kukumchan cases? A coparcener from a joint family was sent to England for the education, and with that help of education, he became a member of the Indian Civil Service. So what the court held was that whatever salary that officer got becomes a joint family asset. Please note it, this salary is not his own asset, it belongs to joint family because he has been sent to England for the education. So the whole scenario was considered as a specialized training, and because of which the salary of the officer has become the joint family asset. Because of Gokulshin versus Hukumchan case, Hindu Gains of Learning Act 1930 was passed. According to this, whatever education, either it could be ordinary education or specialized training that was happened with the help of ancestral property, and all the gains of learning are only self-acquired property. Thus, as a result of this act, irrespective of ordinary or specialized training, it always will be considered as self-acquired property and not a joint family asset.